Welcome to the last panel, and I hope that you will have enough energy to join the last one. I'm Bùi Tiến Đạt from the VNU School of Law, and I'm very pleased to be the chair of this panel, namely economy and workers, labor. And first, I would like to introduce shortly of this panel. This panel session discusses how public emergencies impact on the economy and social economic rights in Vietnam. We will discuss several countries like Vietnam, US, China, Indonesia, and Singapore. And the allocation of time for this session is we have 3 parts, as you can see. The chair's summary of the papers, maximum 10 minutes. Second, the chair's questions and authors' responses in 15 minutes. And the last one, we will have further discussion, maximum 25 minutes. And we have 5 papers from several authors. For today, Professor Nguyễn Xuân Thảo from the USA cannot join the conference, but we will still have provide a summary of a paper. The first one, the paper from Professor Phạm Thị Hồng Nghĩa, Role of the Bank in the State of Emergency. The author highlights the role of commercial banks in emergency situation, particularly receiving deposits, credit extension, and payment services. The paper makes recommendations for state agencies, banks, and their customers in order that banks can play their role in stabilizing and developing the nation's economy during and after the state of emergency declaration. The second one, in the paper, Contracts as Emergency Law, Injecting Certainty to Uncertain Times. Professor Nguyễn Xuân Thảo from Indiana University raises the importance of the idea of contract law as private emergency law in US and China, with the aim of injecting certainty to uncertain times. For the third paper, Measuring Public Health Emergency and the Exigency of Indonesian Financial State Policy and Financial System Stability. Professor Go Lissaunawati from the University of Surabaya, Indonesia, claims that the COVID-19 pandemic has brought new approaches in conducting everything, including the implementation of state budget, law, and regulations in Indonesia. The author task force on ASEAN migrant workers, Singapore, evaluates how existing legislation and new measures restrict constitutional rights. The author evaluates how existing legislation and new measures in Singapore restrict constitutional rights to cope with COVID-19. The author explains the reason of no special emergency proclaimed in Singapore during the pandemic, and the pre-pandemic existing legal framework of Singapore is already highly restrictive on people's right to express and assembly, particularly for political expression. The author also raises the fact that during the pandemic, a new act called Protection from Online Falsehoods and Manipulation Act is used extensively by the government on social media postings that are deemed by themselves to be false. And we have the last papers from the VNU Law School. In the paper, Assurance of the Right to Work, the Right to Have a Complete Life in Emergency Status, some experience from Vietnam. The authors claim that the COVID-19 pandemic poses challenges in many ways. the subjects responsible for protecting rights, the degrees of protection of social and economic rights in conformity with the national socio-economic conditions, and the effective responses of the government. The role of existing legislation and regulations in protecting rights in an emergency. To illustrate this point, the authors analyze Vietnamese government's practical actions to ensure the right to work and the right to an adequate standard of living to fight against COVID-19. So that is my brief summary of 5 papers. And now we are heading to the second part of the session in maximum 15 minutes. I provided questions for authors, and now the authors will respond to these questions. First, for Professor Nguyễn Thị Hồng Nghĩa, in your paper, you make recommendations for state agencies, banks, and their customers so that banks can express their role in helping to stabilize and develop the nation's economy during and after state of emergency. My question is, could you point out strengths and weaknesses of current Vietnamese legislation, including laws, decrees, etc., that affect the operation of banks in the state of emergency? Now you can respond in 3 minutes.
Thank you for the interesting question. In my point of view, the current agency have both strength and weaknesses that affect the operation of bank in the state of emergency. For strength, document to instruct banks were timely issued. For detail, in Vietnam. In Vietnam, although state of emergency is not yet announced, the development of the COVID-19 epidemic has outlined the situation of the country in the state of emergency. So I get it as the facts in Vietnam.
Nghe thấy không nghe thấy lấy cái mic này cái mic đẩy cái mic
For strength, the document to instruct banks were timely issued. For detail, in Vietnam, before the events of COVID-19 epidemic, the State Bank of Vietnam issued a number of writing documents, such as the documents requiring all departments in the banking system to implement and prevention and control of COVID-19 epidemics, to protect the health of officials, prevent the occurrence and spread of the epidemic in its areas, and promulgate document to promote bank supporting the roles in economy. They as follow Circular number 1 in 2020 of State Bank of Vietnam. Besides strength, the current legislation also has quickly that affects the operation of bank in state of emergency. In fact, there are no documents that directly consider policy to support bank. In Vietnam, the COVID-19 pandemic has reduced the bank income by about 268 billion Vietnam dong, but state management agency did not issue any document that show the state support bank. Actually, like the other business, bank got support on electricity price reduction and cutting down tax. However, in my point of view, it's not enough because bank take the roles of the nation economy capital transfer station. Bank provide capital for all business in the state. So I think that the state should have much more ask for them than the other business. For example, if the state bank can give the special loans from from the package for banks and refinancing with low interest rates for banks. That's all my saying. Thanks for listening.
Thank you for your answering. And please allow me to turn to the next author, and then we will have open discussion at the end of the session. So the next question is for Professor Lisa Nagwati. In your paper, you point out that the COVID-19 pandemic has brought new approaches in conducting everything, including the implementation of state budget, law and regulation in Indonesia. My question is, could you evaluate whether corruption in relation to state budget implementation increases or decreases during COVID-19 in Indonesia? Thank you.
Thank you, Dr. Dwi Tiendat. Good morning, Professor and colleagues. Thank you for the organizer that has already held this conference. It is very interesting to me for join your conference. And greetings from Indonesia to all of you. Actually, I just put a light exercise in the context of certain circumstances affected by the state of emergency governed by the government of Republic of Indonesia. That now we are in the three conditions. Actually, I can highlight whether Indonesia is implementing the public health emergency. The second is we are implementing the disaster emergency based on the different law, and also the one that put the major problem here is the emergency force. In Indonesia, it has a specific terms called as kegentingan memaksa. This is a specific terms because this is the prerogative rights of the president, as mentioned in the 1945 of the Constitution of the Republic of Indonesia, and it must be meet the three requirements to be categorized as an emergency force or kegentingan memaksa. The situation that give already by different laws, as I mentioned in the papers, actually shows that Indonesia is in the situation that can be categorized as a crisis or dangerous or anything, but it is also arising a problem about the conflict, how to understand the position of certain circumstances. While the COVID-19 pandemic are affected not only the poor, but also those in vulnerable areas, which the government has not mapped out yet. The misuse or abuse of financial budget will bring impact to the state financial laws. Thus, anti-corruption has become an important aspect that should be prioritized during the public health emergency. Some important activities in dealing with pandemics is to provide quality medical equipment, medicine, healthy services in sufficient number through the procurement process, and social protection, such as social assistance, free electricity costs, or basic needs support, and or other activities that relate to the economic condition recovery effort. To respond to the question that addressed by Dr. Dwi to me, let me share. I cannot mention. I cannot compare actually the number of what is case of corruption caused by the financial state laws as you request. But let me allow me to share you. There is actually three cases, but due to the limit of time, I just want to share one apple-to-apple cases with the condition right now that use the state finance before COVID-19. Indonesia has experience in facing the avian influenza outbreak in 2003. The Ministry of Health allocated funds for the procurement of medical equipment and proposed the fund to be used in the procure buffer stock of medical equipment necessary for the public health emergency. The ex-Minister of Health, Mrs. Siti Fadila Supari, was convicted guilty of corruption due to the source procurement of a state-owned company and acceptance of bribes from the other companies. From this case, actually, the state loss is around more than 5 billion Indonesian rupiah. But what highlight here is actually in the position or in the condition of public health emergency, it needs it requires speed or fast action in everything. So what I mentioned before, we have to put a really I mean it is important to understand which condition is could be certain circumstances under the law of anti-corruption in Indonesia. But the case during, as a comparison, during case during COVID-19 has not yet in court process, but some cases have been appear to be investigated. The first case is about the report of alleged misuse of COVID-19 budget in Tanah Datar, West Sumatra, where a group of people reported the task force of Tanah Datar to the local prosecutor office because they are suspected conducting manipulation activities which were not in accordance with the budget plan during the handling of COVID-19. The second case right now is in the investigation of police. It's about the allegation of misuse in the COVID-19 budget, as well as the distribution of support from the government to the community in the West Bandung Regency in 2020, where the community got rotten food from the government, local government. And the third, and now is still in a running case, is about the patient of COVID-19 that still have to pay for the hospital, even though the expenses shall be borne by the government. After it confirmed by the local government, the hospital normally say that it is a misunderstanding of something like that. But still, it is in an inquiry of the what is as a investigator. And the other cases also that the inflated electricity bills that still shocking citizens is still now being the case that we are coming in this position. Thus, it needs to pay attention to the potential corruption that may appear in using the state budget in Indonesia. And this morning, yesterday, President Jokowi, our President Joko Widodo, has stated that if there is people who took opportunity for for enriching himself amid COVID-19, presidents allow the law on corruption to be implemented to that person. So it is the point that should give underlines comparing to the law number 2 of 2020 about the exigencies of the financial state committee, stability committee. That's the point that I want to share, but for the rest, you can see in my small paper that I already give to the committee. Thank you very much, Dr. V.
Informative answer. And now I would like to show the question to Professor Sinaphat Samidorai from Singapore. In your paper, you evaluate how existing legislation and new measures restrict constitutional rights to cope with COVID-19. The question is, what do you think about the constitutionality of the Protection from Online Falsehoods and Manipulation Act? Thank you.
Yeah. Hello. Can you hear me?
Yeah.
Thank you. Firstly, I would like to say I'm not a professor. You address me as a professor, but I'm not a professor. Yeah, I will go on and address that. Actually, yesterday, Mr. Darius Lee addressed the issue of security laws and other existing policies and law in his paper. I will not go into them. Singapore is a supposedly advanced country, but unfortunately, I think we do have very restricted rights in terms of freedom of expression, even though our constitution does give in Article 14 the right to freedom of speech and expression and assembly in a way. But then if you look carefully in the next article, Article 14(2), it says the parliament can restrict the right to freedom of speech and expression based on the interest of national security. The parliament can decide on this. And also based on our relationship with other ASEAN countries like Malaysia, Indonesia. If there are some disputes, they can restrict these things. Also in terms of privileges of the parliament, if someone is critical or they question the parliament or parliamentarians and the ministers, things can also be further restricted. The new law that came in last year is actually to address criticism that or false news that are happening in the social media, internet, or even by Facebook pages and others. So basically, this necessitated the government to come out with a new law to restrict this space. The Protection from Online Falsehoods and Manipulation Act that came into power effect in last October. And we can see the impact of this already by January. The government begin to use this act, especially in the COVID situation, which is new. The disease is new, and the interpretation of how it is spreading, the number of cases that are spreading, or how it's being handled by the government came under criticism, and Facebook pages or online pages used by Singapore groups critical of the Singapore handling of this situation of COVID. So we can see in January, there were already this Facebook page and other mechanisms, Google and others were given, Performa did not came into to control them until January. The leeway given to them was lifted. And we can see that the government actually coming down on the people to say that the information they have given in their Facebooks or their pages or web pages are wrong, and they have to put it that the news is false. While they can maintain the page there, they have to say this information is false, and they have to give the government's interpretation. So that is a big issue. And if you don't follow that, you can be fined heavily. You can be sentenced to jail, 10 years maximum, okay? The fines can be heavy. For Facebook and others, they can be fined as much as $1 million Singapore dollars. So I think this is an issue. We already have a very restrictive situation. Here we are saying they are further restricted in a platform. We thought there will be much more space for expression. So one of the fears that civil society and human rights groups were expressing is this new law would be used as a censorship mechanism. Anyway, this is a reality. So I think that has to be looked at, I think, carefully. So I would not go further deeper into it, except that this is a new law and it has added a further instrument in the hands of the government. So if there are further questions, I can look at it and I can answer it later.
Yeah, thank you very much for a very detailed explanation of the Singaporean system. And next, I would like to raise the question for Professor Chu Hồng Thanh and Dr. Nguyễn Thị Thanh. In your paper, you analyze the Vietnamese government's practical actions to ensure the right to work and the right to an adequate standard of living to fight against COVID-19. The question is, in section 1.2 of your paper, you present an observation. In the event of an emergency, all civil, political, economic, social, and cultural rights are limited or affected to varying degrees. Do you think that the right to work and the right to an adequate standard of living are two rights that are most significantly limited or affected during the COVID-19? Thank you.
Yes, good morning, everybody. As Professor, Doctor, and friends, we thank you so much for the interesting questions. Our papers include two people, two actors, I and Dr. Nguyễn Thị Thanh. We nominate Dr. Nguyễn Thị Thanh say some words to answer that question. Thank you. Please, Dr. Nguyễn Thị Thanh.
In my opinion, in the state of emergency against the COVID-19 pandemic, it's difficult to say with a human rights argument effect because it depends on a specific duration of prevention and control of each person in the community. A specific situation will reveal those specific needs, which will determine with right each one significant effect. For example, individual A has been effect compared with individual B not effect. Certainly, A must be insulated from a community to treat the disease, and B only have to comply with requirement and treated on wearing mask, clean hands, and distance in communication. So the issue of ensuring the freedom of A and B in the community is different. The restriction of right is also different, depending on a specific situation. Its effect in prevention of COVID-19 in Vietnam and in the world shows that individuals lose their job and retreat in job or their income reduced and have difficulty in meeting their essential needs. There are very hotly discussed topics in many different forums. We argue that zero little right group among the most significant effects. Thank you.
Thank you, the two authors, for your answer. That is the last papers of the question and answer from the chairs. And now we are open to further discussion for this session. And now I received two questions for Professor Phạm Thị Hồng Nghĩa and Professor Chu Hồng Thanh. The first one, for the first paper, the question is, what have Vietnamese banks done to support the economy in COVID-19? And can I ask Professor Phạm Thị Hồng Nghĩa answer this question?
It's interesting question. I think that in COVID-19, the Vietnamese banks take important role in support economy. Firstly, we can see it in the three aspects of the bank activity. First of all, in receive deposits in order to fulfill their roles during the COVID-19 epidemic, banks slightly reduced deposit rate so that people who safely deposit redundant money into banks. Despite we are using lending interest rates to support the economy. Secondly, in the credit retention, banks have clearly shown their roles into the economy and society through decreased interest rates 0.5 to 1.5% for existing loans which were affected by COVID-19 pandemic, reducing the average interest rate by 1 to 2.5% for the new loans. They also debt restructuring for the customer. Thirdly, in the non-cash placement operation, due to the risk of sparing the disease during using cash in the time of COVID-19 pandemic, Vietnamese banks have implemented the extension or reduction of placement fee. This has led to a surge and cashless placement transaction. That's all myself. Thank you.
Thank you. So now we have two questions for Professor Chu Hồng Thanh and Dr. Nguyễn Thị Thanh, and you can answer these questions all together. The first one is, in your view, what roles of the government and social partners, employers organization and workers organization could have played in assuring the right to work and the right to an adequate standard of living in Vietnam? And the second question is, the authors propose that Vietnam is required to enact a new law to ensure the welfare of the people. However, Vietnam so far owes a number of regulations as well as indirectly implementations the convention that it has ratified. On the other hand, the author provides that Vietnam has well responded and there's room for response by far. Hence, question is, it is requiring Vietnam to enact a new law. It is a suggestion for other countries. Thank you. And Dr. Nguyễn Thị Thanh, can you answer these questions?
Thank you. I would like to the question from Mr. Ha. Yeah. In my view, both of government and social partners play an important role in ensuring the right to work and the right to adequate standard of living. According to international human rights law, the government has the responsibility to respect, protect, and ensure the implementation of human rights in general, including the right to work and the right to adequate standard of living. For the reasons, employer obligation and worker obligation are also responsible for respecting, protecting, and ensuring work rights, including work right and right to adequate standard of living. As the government make decision and regulation on ways, mentors, standards, finance, and conditions to ensure employer obligation have a direct responsibility to ensure work rights. Each person, the government even need to support the obligation in own respect, mental, financial, operational, entity, including supervision and review of decision and government implementation measures to ensure human rights. It's equivalent in Vietnam shows the government and organization as pioneer calling for conversing the unity of the community and people. In emergency situation is writing for again a pandemic and cooperation while protect human rights in a pandemic. Thank you. And the next question that the Associate Professor Thu can answer. Thank you.
And for the second question, can Professor Chu Hồng Thanh can explain for a while? Vâng, câu hỏi là vai trò của vậy cái vai trò là chúng ta cần phải có một cái luật mới để đối diện với tình trạng khẩn cấp tương tự để bảo vệ cái quyền của người lao động, đúng không? Rồi quyền được sống trong cái quyền được sống một cuộc sống đầy đủ ở Việt Nam như thế nào ạ? Thì thầy Thanh có thể đưa ra lời bình luận là liệu chúng ta cần xây dựng pháp luật mới để có thể bảo vệ cái quyền kinh tế xã hội nói chung tốt hơn trong cái bối cảnh khẩn cấp, ví dụ ở Việt Nam hay không?
In our opinion, in our papers, we want to share you some experience from Vietnam in COVID-19 emergency situations. I think in this case, Vietnam did not waste time and effort in insurance in new law, in not needs waiting for new laws to adjust to emergency situation against COVID-19. The government were very flexible, but still being cautious in applying to the exciting laws on the preventions of unpredictable epidemics. Many surprises may occur. I think we have sent you some experience from Vietnam, but the most important experience is need to root national love, solidarity, national pride and responsibility, include social responsibility, legal responsibility to the community of every citizens and age groups and all peoples in Vietnam country. Social organization in an emergency situation in not only COVID-19 emergency situation. I think so. Sometimes in Vietnam, in this case, not needs have new laws.
Thank you, Professor.
Thank you for very interesting questions.
And now I see some more questions. For Professor Lizanawati, how does Indonesia have policies to stabilize financial resources for economic activities to recover from COVID-19?
Yes.
Yeah, please.
Yeah.
Yeah.
Thank you, Dr. Thuy. Thank you to Queen May for the question. Actually, based on the law number 2 of 2020, as the establishment of the government regulation in lieu number 1 of 2020 as a law, we can see there's a lot of schemes that given by the government of Indonesia. Such as like stimulus, relaxation, refocusing, or something like that. Let me try to brief something like the government can issue like the state bond or Sharia state bond with a specific purpose to be to be bought by the Bank of Indonesia, state-owned company, corporate investor, and then government also lend the Indonesian Deposit Insurance Corporation to conducting focusing and postpone the distribution of transfer of region and village funds. And then government of Indonesia has also give provides a tax relaxation by adjusting the corporate income tax and permanent business entity tax rate, namely around 22% for 2020 until 2021, and many more as provided in this law number 2 of 2020. Thank you so much.
Yeah, thank you.
Nhớ, hai chị.
And we have a very detailed and interesting question to Mr. Samigarai.
Tiền của
Singapore did not declare a
Question is important. When Singapore had the first case in January 23rd and right up to March, it focused on the local population. I mean, the citizens and residents of Singapore, the permanent residents. And it was praised by the World Health Organization, who, as a golden standard. It is true, Singapore was quite effective in managing the issue even without imposing an emergency. But what happened after that, the weakness of Singapore, the discrimination or discriminative attitude towards migrant workers appeared. Migrant workers were left out. There were about 300,000 migrant workers staying in dormitories in very crowded conditions where social distancing and other things are very difficult, with one toilet per room, which each room occupy with occupants of 12 to 20 workers. Imagine that. There are 1.4 million migrant workers, and Singapore in the labor law, although it has protection for workers and it applies the most, but it can be applied particularly in terms of wages and conditions of work can be discriminated towards in the terms of migrant workers. Same work, same job, migrant workers from different countries can pay different. I'm not going to detail, it can take more time, but the fact is, since mid-March, the migrant workers cases of COVID-19 spiked. And now we have 40,000 plus, more than 90% are migrant workers. So I think this is the problem. This problem of housing dormitories were known since 2015. There was a law made to better house them, even to have a treatment if there are epidemics, but unfortunately it was never implemented. So right now the government is trying to ratify that under COVID situation. They are building new dormitories with better space for migrant workers. We have to see how effective it is going to be. I think Singapore did not sign the ILO Convention 111 on non-discrimination and also the right to organize. So I think these are improvements Singapore need to do, and other countries in ASEAN also need to do. You can't discriminate migrant workers who are part of your country who are working in your country. If you do, it will impact, it will spread. The disease like COVID epidemics can spread. Okay, I'll stop there unless you want to have more explanation. Thank you.
Thank you very much. So now we have 4 minutes left. So please allow me to have 1 or 2 minutes to have a brief comment. The limit of the government powers to restrict rights. So we have might have different approaches and perspective to this type of rights. And I agree with some authors that for this kind of rights, we should respect the discretion, the policies of the government, as I understand. And besides, we need to control the role of the National Assembly or the legislative to provide the act or the laws to give the discretions for the government, and we should take consideration into the role of the court to assess the legality of the government actions in providing measures in specific cases. And that's my brief comment. And now we still have 2 minutes. Do you have anyone have want to say something before we end this session? Well, okay. So thank you very much for speakers, participants for this session. And now I would like to end this session and hand over to the organizers. Thank you.